Namaskar, hello and welcome viewers. You're watching this special presentation of Sunset TV, Bills and Acts, where we analyze bills that impact you, acts that empower you, and programs that matter to you. I'm your host Kriti Mishra, and today the spotlight is on the National Investigation Agency Act. Before the detailed analysis, let's take a look at the highlights. National Investigation Agency Act 2008 provides for a national-level agency to investigate and prosecute offences listed in scheduled offences. The Amendment Act seeks to allow the NIA to investigate the offences related to human trafficking, counterfeit currency or banknotes, manufacture or sale of prohibited arms, cyber terrorism and offences under the Explosive Substances Act. Further, the Act allows for creation of special courts for the trial of scheduled offences. So why are we discussing this Act today? Well, the National Investigation Agency registered an all-time high of 73 cases in 2022, even as it is working to undertake a whole-of-ecosystem approach to dismantle the terrorist networks that aim to harm India. Among the cases registered this year include 35 cases of jihadi terror in J&K, Assam, Bihar, Delhi, Karnataka, Kerala, Madhya Pradesh, Maharashtra, Rajasthan, Tamil Nadu, Telangana and West Bengal. 10 cases related to left-wing extremism, 5 cases related to insurgents in the northeast, 7 cases related to the PFI, 3 cases of gangster, terror, drug smuggler nexus, 1 case of terror funding, and 2 related to fake Indian currency notes. The agency also filed a total of 59 charge sheets against 368 persons during the year. Judgments have been pronounced in 38 cases in 2022, all of which have ended in conviction. 109 persons have convicted to rigorous imprisonment and fine, and 6 life sentences have also been awarded. The overall conviction rate for the agency currently stands at 94.39%. Remember, the NIA is a central agency mandated to investigate all the offences affecting the sovereignty, security, and integrity of India, friendly relations with the foreign states, and the offences under the statutory laws enacted to implement international treaties, agreements, conventions, and resolutions of the UN, its agencies, and other international organizations. And for deeper insights on the Act and working of the NIA, I'm joined by eminent panelists. Joining us on the program today, Mr. Narayan Das Gupta, MP, Rajya Sabha. He represents the Aam Aadmi Party. Also joining us, Dr. Justice Satish Chandra, former judge, Allahabad High Court. And also joining us on the program, Mr. Navneet Wasan, former DG, NIA. I welcome all of you on Sunset TV and thank you so much for joining us. And let's commence this discussion with the Member Parliament on our panel. Mr. Gupta, coming to you first. All of us know that NIA was constituted in the wake of the Mumbai terror attacks of 2008. So almost 14 years of its existence. How do you see the contribution of NIA in fortifying India's internal security?
Because this first time it came in 2008, you have rightly said. After that, the amendment which came in July 2019. And the scope of the NIA was increased through that amendment. As far as the cases are concerned, because in the last session of the Rajya Sabha, the State Home Minister Nityanand Rai, he made a statement and he gave the figures of the cases, which I can share with you. The total cases so far registered is 497, under investigation 325, judgment pronounced 67, and the investigation is pending about 105 cases. This is the situation in today's date. And you have rightly said the scope you have already said regarding the sovereignty, integrity, and the with the relationship with the other countries. That is the purpose. Now this amendment which came in July 2019, that there were 5 amendments which were made, and the scope was enlarged. And the one was that the investigation which was not earlier in connection with the outside the country, that was included, that is one. Then the parallel power has been given to the NIA officer as per the powers are available with the police. Then the empower the Union government of direct agency to register the cases. And provision of special courts was also, that was session court, that was the power given to them to handle these cases. Besides that, the scope, as far as scope is concerned, 5 more the things were, one was the human trafficking, counterfeit currency, fake currency, manufacture and sale of prohibited arms, cyber terrorism, offences under the Explosive Substance Act. These amendments came through this, the scope was increased. But I would like to share this regarding the cases registered and pending investigation, whether we are able to achieve the target or not, as per the statement made by that. Similarly, it is happening, I would like to, if I permit to share, under the this PMLA Act, because the ED is handling. So far, this is also as per the statement given in the Parliament, 3,000 cases are registered, only 3 cases have been prosecuted. This is situation. Question is, the power has been given parallel to the police. Whether the police is able to justify their duties or responsibilities, that we have seen recently a case of Kanjawla case. How this case is every day more and more thing. But question is, we have to that the more attention is required in today's date. I have the privilege to share with this program with the Honorable Justice, Honorable Purvad DG of the NIA, whether we are able to justify the purpose, we are able to achieve the results and target for which this NIA was, it came in 2008 and further amendment made. This is what I can share with you.
All right, sir. So a concern that you flagged, I'll take that to Justice Chandra. Justice Chandra, of course, we know that the conviction rate of NIA is almost 95% better than any of the central agencies. But Sir has raised some of the concerns. Would you like to allay those concerns?
Look, as you told, that conviction rate is very high in comparison to other agencies. So it is telling what agency is doing or what is the net result of this one. But before coming to other aspects, I would like to tell you that this, our Enforcement Directorate is dealing with the PMLA, Prevention of Money Laundering Act, and NIA is dealing with the Unlawful Activities Prevention Act. And the genesis of this Unlawful Prevention Activities Act, which dealt by this NIA, generates from the year of 1962. After the China War, the National Integration Council has decided to appoint a committee on the integration and sovereignty problems in India. And that committee had given the report. And on the basis of that report, 16th Amendment was created in the Constitution in the year of 1963, where it was said that reasonable restrictions in the interest of the sovereignty, integrity can be imposed by law. So that was the basic starting point. After that, UPA Act, Unlawful Activities Prevention Act, 1967 was passed by the Parliament, and where it was said prevent the unlawful activities and connected activities by the individuals, associations, and other persons pertaining to the terror activities. And what is the terrorism? What is the terrorism? This has been defined under Section 15. For the young generation, I am telling you why it was defined. In Section 15, it was intent to threat or likely to threat the unity, sovereignty, integrity of India that will cause for this one among the people or neighboring state. Today's newspaper is telling that Jihad-ul-Hal, another organization of Bangladesh, who was having a camp in Tripura, that was detained by the NIA or destroyed by NIA. So this is there. Here I would like to mention that integrity, unity, and this
sovereignty of India.
These words were not in the original constitution.
That's true.
These words were added by Indira Gandhi's 42nd Amendment in 1976 in the preamble of the Constitution. But these words were dealt in the 16th Amendment of the Constitutions.
Right,
these words were dealt. So after this one, how this terrorism will work and what they will do for the generation, young generation, this will be the explosion. Anywhere, explosion is there and causing the death, injury, and disruptions of the essential supplies, and kidnapping, detention, and being a member of this terrorist organization is also punishable. Who is harboring, giving the shelter, providing the place, recruitment for the new persons, and that will covered by this one. Power was given under Section 51 to impound the property, to impound the passport.
Right.
Zakir Naik passport was impounded and all property was seized in this case. After that, UPA Act amendment was there in 2012. Yes. 2012, there was an amendment in that. And 2EA section was added, which provides that security of India will not be merely a security, but economic security.
Right.
And economic security, food security, energy security, ecological, environmental, and livelihood. All these were covered by the word of the security.
Right, sir.
Another amendment was made, the production, circulation, the high quality of currency note, FICN and coins. That were also added. Section 24.2, production, circulation of the high quality note. 22 section says the company's law. Any promoter or any person who is engaged in the business of the company will also liable to the punishment if that company is involved in these offences defined in the Unlawful Prevention Activities Act.
Right, sir.
So that was there. And second schedule was also added where you rightly said convention, international convention, conferences, treaties,
Right,
they were
treaties.
involved.
Right,
so
sir.
this was the history of this one.
Right.
And after the Bombay blast and these things, earlier this was done by the normal police. All these activities were done. But they thought that there will be a specialized agency. In 2008, they created by statute the National Investigating
NIA.
Agency.
Right, sir. Right, sir.
Which was amended in 2019.
Absolutely, sir. Thank you so much for taking us through those highlights. But Mr. Vasan, you've headed this agency. Some concerns that were raised by Mr. Gupta, how do you allay them? One. And second, the government has been talking about agency-like approach for the NIA, probably something that we see in the US, what the FBI does. Help us deconstruct this notion.
Coming to the genesis of National Investigation Agency,
Yes, sir.
everybody knows that in aftermath of 26/11 at Bombay, the Parliament almost unanimously passed this legislation and this agency was brought into existence by using the entry Defense of India and in List 1. Hitherto, it was Central Bureau of Investigation and the State Police which used to investigate terrorist offences. But the Central Bureau of Investigation had a difficulty because many a times the states were not ready to hand over cases to Central Bureau of Investigation, which is technically known as Delhi Special Police Establishment, to get over that problem so that, the investigation into terrorist offences can be handed over to a federal agency without any hindrance. This agency was created and it was given a pan-India jurisdiction where no prior consent of the state governments were required, as is required in the Delhi Special Police Establishment Act. That's the one very important component why this agency was brought into existence and what powers it had. Now this agency is, we must know, is a post-incident investigation agency, unlike Federal Bureau of Investigation. Because Federal Bureau of Investigation is both charged with collection of intelligence as well as post-incident investigation. That's the very fine difference between the two agencies.
True.
In India, the intelligence is still collected by different agencies and NIA undertakes the investigation once a case is registered.
Right.
Now, I don't see, because terrorism is one such area where nobody can have any difference of opinion that it is dangerous, it is a challenge to the sovereignty of
Absolutely.
the nation, integrity of the nation.
Absolutely.
So, the moment such an offense takes place, this agency takes over the cases as directed by Ministry of Home Affairs and undertakes investigation. Now, as is evident from the conviction rate, the agency so far has been doing a very professional job and hopefully it will continue to do a similar kind of professional work in future,
Right.
because it is extremely important. Now, another thing which has become very, very crucial, which I must talk about it. Now, recently the amendment in 2019 was brought in, wherein cyber terrorism, which is in the Information Technology Act, was also entrusted or brought into the schedule of NIA. This is one area which is going to be a big challenge for not only India, for many other countries also. And where there is a need to develop expertise, because these are very, very difficult cases to investigate, because it requires a lot of technical knowledge, a lot of technical input,
Right.
and a lot of collaboration with other countries. Because most of the time, the terrorists operate or they commit cyber offenses or cyber-related offenses sitting outside the
India.
boundaries of India.
Right, sir.
This is one area which has become very crucial, and I hope the government and the agency will take steps not only to educate their own investigators in the technology, as well as also entering into various treaties with other countries to get information.
Absolutely. That's a very legit piece of information that you've given us. But before we move on, let's take some questions from our audience here.
How do you see the amendment of 2019 as affecting the federal structure, particularly when seen in context with the UAPA amendment, the change of the nature of one of the Indian states without asking the legislature, and prevention of media from accessing certain areas? Do you see it hampering the center-state relations, as the amendment gives the NIA rights to supersede the states in taking up cases?
But the fact that the NIA amendment bill was unanimously passed.
See, that is true. In the parliament, it was unanimously passed, because the question is, when the debate takes place on any amendment bills, all parties, they give their own views. But finally, I have seen with my own experience, bills are generally passed unanimously. Now the question is about Jammu, Kashmir and other things, because that is not without that, you have said, without the legislature of the Jammu and Kashmir. There was no government at that time. It came. There was a representation from all states in the Rajya Sabha, and it was discussed, thoroughly discussed, and finally, unanimously it was passed. As far as concerned, there was no such thing that without the consent of the Jammu, Kashmir or anything, there is no distinction made between the state to state. It is discussed, and representation from all states, people are there. Even there were members of the Rajya Sabha from the Jammu and Kashmir state. They also participated in the debate.
Absolutely. Even the Parent Act and the Amendment Act.
Yeah.
Both the acts.
Yeah,
Sir, would you like to take that?
Yeah, coming to the question, does it affect the federal relationship? And my answer to that will be emphatic no. Because terrorism is such an offense which does not have, as I told in the beginning, has any boundaries. So once an offense takes place, the ramifications or the investigation has to take place in jurisdiction of more than one state or even outside India.
Right.
So therefore, no state police agency would be equipped to handle these cases appropriately, properly, in a professional manner.
Absolutely.
So therefore, no way and no state, when a state police cannot investigate a case professionally, then what is the alternative available? You have to have an agency which has a pan-India jurisdiction, which can take the investigation to a logical conclusion and thereafter file charge sheet, and you are seeing the result. In most of the cases, the NIA which have investigated are ending in conviction.
Absolutely.
So
quick word from Justice.
May I add to it?
Yes, sir. Please go ahead.
Because, for your information, so far as I have said, 67 cases has been pronounced. Out of that, 65 resulted in the conviction. Only 2 acquitted. And they are from all parts of the country.
That's right.
That is there. That's rightly said. Federal system is very well working as for this concern.
Quick word from Justice Chandra before I take another question.
Yeah, we have a quasi-federal system, not the federal system, first of all. And whenever court cases are there, the Union of India, in all the cases, that is there. So here the question is about the integrity and sovereignty. So it will not affect the states' relationship with the center.
Absolutely. It's
Certainly.
all about upholding the sovereignty and integrity of India. Let's take another question.
My question is that the Act has vested the power as that of a special court with the sessions court that are existing. Now here the 2 points come. Number one, that these kind of matters are to be dealt very consciously and they are to be dealt with special emphasis. Now when we see the data of pendency of cases in the sessions court, that is increasing day by day. And secondly, when these cases will also come, because the existing sessions court will be dealing with this. Now my question is, are those sessions court also be invested with the power of dealing with these matters as a fast track matters? Because Or do we have that kind of infrastructure to deal with these kind
Justice
of
Chandra, do we already have?
This is
Yes, sir.
connected with me.
Yes,
so
sir.
I will
Please
give
go
the
ahead.
reply. As far as this session courts that was given in the Unlawful Prevention Activities Act that will try. Earlier, the session courts were doing this job. But by the amendment in 2019, the special session courts were converted into the designated courts. And for that purpose, the NIA will write a letter to the CJ concerned of the High Court, and who will depute the session judge or district judge for this specialized court, that is the designated court.
Right.
And that will be a separate and nothing to do with the regular matters.
All right, let's take another
That's why
question.
it will be a
Yes,
fast.
sir.
It will be a fast track.
Yeah,
court.
this exclusively they will deal with this NIA.
Yeah,
matter.
and look at the conviction rate also. That
Yeah.
speaks for
And
itself.
day-to-day basis trial will be there.
Yes, sir. Please go ahead.
In the provision of NIA Act, which states that there is a provision for the NIA, special provision for the NIA, which allow NIA to conduct any overseas operation anywhere in the world. My question is, this may lead to create diplomatic issues and effect negative impact on our foreign relations between other countries.
Let's get the answer from the former DG. Please go ahead, sir.
See, let me explain it to you. Most of the countries, like United States, they exercise what is called extraterritorial jurisdiction. A word has become a global village. My interest, that is India's interest, many times lies outside the boundary of the country.
Absolutely.
Our embassies, our trade, our, so many Indian people are working outside the country. Whenever any Indian interest is affected by a terrorist activities, we have extended the jurisdiction, and this jurisdiction will be exercised in the light of various treaties,
Right.
conventions, as well as diplomatic relations. Where, say, for example, if we don't have a good diplomatic relation with another country, we will not be able to investigate.
Of course,
that.
absolutely.
So, if you remember the 2611, America, they conducted their own trial because one American citizen was killed in that incident, and they convicted people in America. They exercised extraterritorial jurisdiction because the American interest was impacted.
Absolutely.
I hope that
Justice
makes it
Chandra, you
clear.
wanted to make a point?
Just to reply this boy, the 2019 amendment provides the jurisdiction, overseas jurisdictions outside India, subject to the treaties. Subject to the treaties, treaties means the agreement between two sovereign states, that is known as the treaties, or according to the subject to the treaties and the domestic law of that country.
Right.
Then we will have. This is a special provision made.
Absolutely. Let's take the last question.
My question is related to the cyber terrorism. Earlier, the investigations were made by the state agencies, but now the NIA is making investigations related to offenses. So the state agencies were not that much capable. So what special arrangements are made to make the investigations?
Sir, would you like to answer that one?
For tackling the cyber terrorist investigation, as I told in the beginning also, see, the NIA is training and retraining its own staff in handling these complex cases of cyber terrorism. Apart from that, the NIA also takes assistance of domain experts who are technically have knowledge, and they support the investigation, which was somehow, and very important aspect which you must remember, because most of these investigations will take place not only in India but outside, because many times your servers are located outside Indian boundary in other countries. So we need data from there. We need knowledge as to who was operating a particular portal, a particular website, or particular chat, or anything. So we need cooperation. So cooperation, international cooperation can be handled much better by a central agency as compared to a state police. Therefore, NIA has been rightly entrusted with this job, and in future, as I also mentioned, this is going to be one of the major challenge which NIA will have to handle.
Absolutely, sir. Thank you so much for putting things in perspective. I'm completely out of time. Thank you so much for joining us, Mr. Gupta, Justice Chandra, and Mr. Vasan.
Thank you, sir.
Well, viewers, that's all we had for you in this edition. Thanks for watching and stay tuned to Sunset TV. Goodbye from my side for now.